Hello, this is Attorney Rob Melick, and I'm presenting here at the video version of the Client First Lunch and Learn that was originally occurred on September 22nd, 2020. The topic of this Lunch and Learn presentation is 2020 Vision for Estate Planning, using the mistakes of others to clearly see how to avoid them and secure your future. My name is Attorney Rob Melick. I'm the estate planning attorney who has the privilege of working with Client First Tax and Wealth Advisors. This presentation, I've had the privilege of doing quite a few lunch and learn presentations and YouTube videos for Client First. This presentation is going to be slightly different. As opposed to broadly hitting on a few topics, this appearance is going to focus more on a smaller number of topics, but approaching many more topics during this presentation here. My plan is to go through 20 different mistakes that people make with estate planning. Having the privilege of practicing for 13 years, I've seen many people make many mistakes, have many incorrect statements regarding estate planning, and then I thought of the idea of 2020 being that it's the year 2020, of course, trying to make sure that we are able to identify those 20 mistakes, but also provide 20 solutions to those mistakes. So the first slide that we have here, vision in the law, as demonstrated by Attorney Gambini. For those of you who aren't aware, this is a scene from the 1992 movie My Cousin Vinny. Probably my favorite law-related movie. There's a couple other ones that are up there, but this one I highly recommend. Parts of it are not very appropriate. I will state that ahead of time. But the link to the scene here is appropriate. There are no curse words. It's just a pretty funny scene that demonstrates how vision can apply to the law. And I think it's a nice little clip there. It's about a 2-minute clip. The link for it will be provided below if you're interested in seeing it. Again, it doesn't substantively relate to what I'm discussing here today, but at the same time, it does provide a good little comic relief for you if you're interested. So let's start with mistake number 1. I call this mistake spousal assumptions. One of the things that I find in my practice is that people automatically think that they can make healthcare decisions for their spouses. So a common example would be this. I meet with a husband and wife, and we're discussing estate planning options, and I mention to them the importance of a healthcare power of attorney. Frequently, one spouse will say, well, I'm married. I already have the ability to make those decisions for my spouse, or of course I have the ability to make those decisions for my spouse. Well, unfortunately, no, you don't. The only way that even spouses can make medical decisions for the other spouse is to have what's called a healthcare power of attorney. So that's how it relates on the healthcare side. On the financial side, a lot of spouses automatically think that because Wisconsin is a marital property state that they have the ability to exercise dominion over their spouse's individual assets. So what do I mean by individual assets? Most of my married couples, certainly not all of them, but most of them own most things jointly. For instance, most of my married couples own real estate jointly. They own bank accounts jointly. However, there are some assets that by law they cannot own jointly, IRAs and 401ks being among them. The I, after all, in IRA stands for individual. So two people cannot own an IRA. What's very common for married couples is spouse 1 will own the IRA and list spouse 2 as what's called a primary beneficiary. Well, the beneficiary only has the right to receive the money when the owner of the asset dies. If the owner becomes incapacitated, the beneficiary has no rights whatsoever. So that money stays in limbo unless and until a financial power of attorney is created. So that's why even married couples need to have health care and financial powers of attorney so that they can make decisions for their spouses in the event that one spouse becomes incapacitated. Mistake number 2. This is what I call set it and forget it. I have a lot of clients who fall victim to this. What ends up happening is this. At some point in the past, be it 5 years ago, 10 years ago, 15 years ago, 40 years ago, it doesn't really matter. A lot of my prospective clients come to me and say, well, I've already created an estate plan. I don't need to do anything more. That plan worked then. It was intended to work forever. It doesn't have an expiration date on it. Why do I need to update the plan? And the expiration date is important, right? It is true that wills and trusts and other estate planning documents do not have an expiration date. I always use the expression, it's not like a gallon of milk. However, life happens. I'd be willing to bet that most people, when they look back on estate plans they did in the past, depending on how long ago it was, may not reflect how they want the estate plan to proceed once the second of the two of them pass away. Therefore, it's important to make sure they stay updated. I always encourage my clients to look at their estate plans every few years. Every 2 years is the standard that I use. And I encourage them to ask themselves 2 questions. Question 1, if I or myself and my spouse passed away within the next couple years or within the next day, whatever standard you want to use, are the people who we want receiving the proceeds of our estate receiving them? If the answer is yes, then we keep it the way it is. If the answer is no, then we may want to consider updating the plan. The next question would be, are the people who we want overseeing the estate the people overseeing it, the people in charge of making sure the distribution goes where you want it to go? Again, same thing. If the answer is yes, then we want to make sure that we keep it that way. If the answer is no, we probably want to look at updating the documents. So again, one of the things that I found in my practice, just talking to existing clients of mine, is that sometimes attorneys may either intentionally or unintentionally give the idea that the estate planning process is what's called transactional. You do it once, you leave it on the shelf, you wait till you pass away. In my practice, I make it a point to make sure that my clients do not leave my office believing that, but rather that they understand that this is a relationship. We want to make sure that the documents are reviewed and make sure that they comply with not only the law, but what your preferences are that may or may not change over time. Mistake number 3, putting off estate planning. I get it. I totally understand why a whole large number of my clients do not want to think about estate planning. They put it off. First of all, humans are procrastinators by nature. It's just kind of the way it is, let alone on a subject matter such as estate planning, which necessarily involves you thinking about your own mortality. People don't like talking about death and dying. Everyone has an awareness, a general awareness, some a better understanding than others, but everyone has an understanding that we're going to pass away at some point. Death is inevitable. So what's the solution? Well, I know it's easy for me. This is easy for me to say this as the estate planning attorney, but get over it. It's important to approach it, it's important to acknowledge it, and it's important to take steps. I always tell my clients it's kind of a 3-step process. The first part is you have to understand the information. Now, I realize I'm proverbially speaking to the choir here because you are taking the time to listen to a YouTube video that relates to estate planning, but you have to be willing to receive the information. So that's step 1. Step 2 is you have to actually schedule an appointment to learn more about it. Unfortunately, just getting to step 1 and step 2 doesn't solve the problem. Step 3 is actually signing the documents that make legal the preferences that you expressed during your meeting. So again, please don't put it off. Again, this is an event that we know is going to happen. There's a 100% mortality rate among the human species. What I've found, and one of the things I take great pride in my practice in, is when I do have clients finally sign estate planning documents, I should say a large number of them are very appreciative of the fact that they can now finally cross an item off the bucket list. Most of my clients know that estate planning is something they probably should do. It's something they should have done yesterday. But at the same time, for whatever reason, life getting in the way, not wanting to think about your own mortality, people put it off. My strong words of advice are, do not do that. Get it done and get it done as soon as possible. Mistake number 4, assuming a will is sufficient. I run into this quite a bit. When I meet with clients, when I talk to people just in passing, when I teach courses at Moraine Park Technical College, one of the common objections that I receive from people is something along the lines of, well, I have an estate plan, I created a will, I don't need anything else. Well, for most people, a will-based plan is insufficient. Most wills are insufficient. Why are they insufficient? Because most wills do not guarantee that the estate avoids probate. Let me define probate for you here. Probate's the process where a court oversees the administration of an estate. When the court oversees an administration of an estate, there's a series of hearings, a series of filings, a series of events that have to occur before assets go from the names of the people who passed away to the names of the intended beneficiaries. Will-based plans do not avoid probate because we're relying upon named human beneficiaries. And of course, we can't guarantee that that human or any human that we list in a will is going to survive. The advantage to the trust-based plan is that the trust can't die. I always tell my clients that people are going to die. Every single one of us is going to die at some point, but the trust itself cannot die. That's why if we create a trust, that's the way we guarantee we avoid probate. In addition, wills do nothing as it relates to what I call incapacity planning, what we were talking about before as far as financial and healthcare powers of attorney. I have a lot of clients, particularly clients who may have created wills a long time ago, 30, 40 years ago. I even had a will the other day that was 57 years old. They didn't have powers of attorney. There were no powers of attorney at that time as far as I know. Now, that was 18 years before I was born in 1963, so I'm not exactly familiar with what the law was 18 years before I was born. But at the same time, what I can tell you is under current law, will-based planning, if it's just the will, by definition is insufficient because the wills themselves do not protect against incapacity planning, the ability to make healthcare financial decisions if you become incapacitated. So if you just have a will, it's very likely that that will is insufficient. We should consider creating a trust as well as financial and healthcare powers of attorney. Mistake 5, guardianship gaffes. One of the things I pride myself on in my practice is being a first-generation lawyer and being a relatively young estate planning attorney at 39, although I get older every year, of course, so I have less ability to say that with every passing year. But I do have 2 boys who are 10 and 8, so they are still minors under the law. One of the most common issues I run into just in social settings, non-work settings, is talking to the parents of my boys' friends or teammates or classmates. And inevitably, just in the course of social discussion, the question comes up, what do you do for a living? Well, I tell them I'm an estate planning attorney. A very common response that I'll receive from those parents is something along the lines of, well, I'm glad I don't need your services for a while. And what I want to say, but social decorum prohibits me from saying it, is, well, I'd love to have the crystal ball that you have so that you know exactly when you're going to pass away. But even beyond that, even if they didn't know when they were going to pass away, when I do follow up the question of, why do you believe that? And I mention to them that guardianship is something that I know they have. Because, of course, if they have minor children who are about my children's age, they're under the age of 18. The way the law works is this. If you have minor children and you do not have an estate plan, the court will determine guardianship of those children if the parents pass away. Period. End of analysis. It doesn't matter what you have. It doesn't matter if you have a notarized statement. It doesn't matter if everyone in the family agrees. The court is nevertheless going to hold a hearing to determine guardianship. The only, and I'll repeat, the only way for parents to conclusively determine guardianship of minor children is to put it in an estate plan. So everybody with minor children should have an estate plan to make sure that their wishes as to the placement of minor children in terms of a guardian is honored. Anything short of having it through an estate plan subjects it to the court's determination. Don't let the courts make that decision. Take the step to create an estate plan so that you can guarantee where your children are going to go if you and your spouse pass away prematurely. Mistake number 6, neglecting the estate planning needs of young adult children. Again, this is kind of the opposite of what we just talked about. If people have children under the age of 18, we need guardianships to make sure they go where you want them to go in terms of who would serve as the guardian. This mistake relates to children who are over the age of 18. The law recognizes what they call the age of majority, the age of adulthood at the age of 18. So once a child turns 18, the good news is we no longer have to worry about guardianship. The bad news is that we as parents lose the ability to make healthcare and financial decisions on behalf of our now adult children. And this strikes a lot of my clients as very counterintuitive and very unfortunate and something they want to do something about. Let me explain through an example that might make it a little easier. I have a July birthday, so based upon where I fell kind of in the calendar, so to speak, I was one of the younger people in my graduating high school class. I graduated at 17, turned 18 in the July before my freshman year in college. My youngest son, on the other hand, Hudson, is not in that situation. In fact, he's in the complete opposite. Hudson's situation is that he has a September birthday. So if we fast forward to September 3rd of 2030, that will be my son Hudson's 18th birthday. He will have just begun his senior year in high school. He's a senior in high school. He's living under my roof. September 4th, 2030, he drives to school, and God forbid he's in a car accident, a bad car accident such that he has to be taken to the hospital and cannot make his own decisions. Even though he's a senior in high school, even though he's living under our roof, do my wife or I have the ability to make healthcare decisions for him? The answer is no, we don't. Do we have the ability to even find out he's been admitted to the hospital? The answer is no, we don't. And that should scare people. That should scare people listening to this, not only who have minor children or have children who are young adults over the age of 18, but it should also scare grandparents who have young grandchildren who are slightly over the age of 18, and encourage their parents to encourage their young adult children to create healthcare and financial powers of attorney, because that is the only way that parents can be informed and make decisions and enter a hospital to make those decisions on behalf of a young adult child who becomes incapacitated. Again, that's one of the most common mistakes I run into, and unfortunately I do hear that from people who've learned that one the hard way. So I'm telling you here, create those powers of attorney. It's very quick, it's very inexpensive to make sure that we have that peace of mind. Mistake number 7, not conveying real estate to the trust. I run into clients very frequently who create estate plans, and the attorney, for whatever reason, didn't convey the real estate to the trust. Now, sometimes that's intentional. Sometimes there's a reason to not convey the real estate to the trust. For example, if the idea is that the home is going to be sold or refinanced in the near future, it may be easier to keep it out of the trust for the time being. But once that situation gets resolved, it's a good idea to convey the real estate to the trust. That's something that can make it very straightforward and easy for your beneficiaries to take care of. The example I think of is this. Think of Fred and Wilma, okay, the Flintstones, right? Fred and Wilma create a trust with me. They really, broadly speaking, have two options, right? They can either convey the real estate to the trust or leave the real estate out of the trust. Let's say they choose option 2 and leave the real estate out of the trust. And let's say Fred dies, okay? So the house, remember, just to give a little background here, Fred and Wilma own the home. They did not convey it to a trust. They created a trust, but they never conveyed the real estate to the trust, and now Fred dies. It's very common under those circumstances for the widow or the widower, once the first spouse passes away, to downsize. I run into that a lot. I grew up in Washington County. I have a lot of clients who live in Washington County. It's a very common scenario where they have the big house with a lot of land, and when spouse 1 passes away, the surviving spouse says, gee, you know what? I don't want to keep maintaining this house. I want to move to something smaller. I want to move in to a condo in West Bend or Germantown, whatever the case is. Well, Wilma is unable to sell the house with Fred's name on it because Fred is deceased. So we'd have to file paperwork with the court to take Fred's name off of it. On the other hand, if we conveyed the real estate to the trust right away, the trust specifies who the trustee is at any given time. Specifically, it'll say Fred and Wilma are the co-trustees while both are alive. If Fred passes away, Wilma is the sole trustee, so Wilma wouldn't have to do anything else. Furthermore, we look at it on the back end. Let's just say Wilma maintains that. She files the necessary paperwork to take Fred's name off the house, but still never conveys it to the trust. And now eventually Wilma passes away. Their daughter, Pebbles, is the trustee of the trust. Can Pebbles sell the home? The answer is no. Pebbles has to remove Wilma's name from the property before she can sell the property as the trustee of the trust. All of this is avoided by conveying the real estate to the trust now. Because again, the trust specifies that regardless of who's alive, somebody, be it Fred and Wilma, be it the survivor of Fred or Wilma, or Pebbles as the successor trustee, has the ability to sell the real estate. Mistake number 8, direct beneficiaries. This is a really common one. Let me explain a little bit about what I mean by direct beneficiaries. And I'm going to take an example that most people are familiar with, which is life insurance. Okay? Whole idea of life insurance is to provide a death benefit to people who are listed as beneficiaries under the policy. I mean, after all, that's the whole reason we get life insurance, right? To pay out to those beneficiaries if we happen to pass away during the terms of that particular life insurance. So a life insurance policy is going to have direct beneficiaries. Now, let's say, and I'll just use myself as an example, that I took out a life insurance policy in 2011. Okay, and I picked that year intentionally. In 2011, if I were to create a life insurance policy, I would list my wife as the primary beneficiary, and I would list my one son, Grady, at that time, who, depending on what part of 2011, would either be 0 or 1, as the contingent beneficiary. Well, as fate had it, I was blessed with a second son in 2012. But let's say I never updated the beneficiary designation. And let's further say that in 2020, I created a trust that listed my wife as my wife and I as the initial trustees. After we both pass away, split evenly between my two sons, Grady and Hudson. But let's say I never updated that life insurance policy. We fast forward to the date the second of my wife and I pass away. Does Hudson get that life insurance? The answer is no, he doesn't. The trust does not supersede or undo direct beneficiary designations. So the solution is make sure that the beneficiaries are in harmony with your estate plan. That's one of the reasons why I'm blessed to have the ability to work with Client First, because we can work both from a financial as well as a legal side to make sure that your beneficiaries on your financial assets that you have with Client First are at least matching up with or intentionally deviating from the trust. In other words, the example I brought up, it was just mere inadvertence. I didn't intend to leave Hudson off of that policy. He just wasn't alive at the time I created it. So again, it's important to understand that the direct beneficiaries, if they're entities other than the estate plan, the trust specifically, that we have to update them to make sure that the assets go where we intend for them to go. Mistake number 9. Spouse passing away. I run into this one quite a bit. What happens is I have a married couple, and this time we'll pick Betty and Fred. We're going down the road here in Bedrock. Betty and Fred are living, I'm sorry, Betty and Barney, excuse me, Betty and Barney. Betty's not married to Fred, Betty's married to Barney, I should know that. And let's say this time Betty passes away first, because again, statistically the male's more likely to go, but let's just say in this instance, just out of the interest of gender equality, Betty passes away first. Barney may go through that process, and under Wisconsin law, it's relatively easy when the first spouse passes away. Wisconsin has marital property laws that make it such that unless there's a prenuptial or a postnuptial agreement, for the most part, assets pass very smoothly from deceased spouse to surviving spouse. Now, Barney may inadvertently think that because the process was easy when Betty passed away, that it'll be equally easy for their son Bam Bam to administer the estate once Barney passes away. And that is not the case. The reason that's not the case is because the law treats it very differently when there's a surviving spouse versus when there's not. So it's very likely that if Barney and Betty did not engage in any estate planning, while the estate would avoid probate when Betty, the first spouse, passes away, it's very unlikely that the estate would avoid probate once Barney passes away. So we have to understand and acknowledge and appreciate and take action upon the differences between when spouse 1 passes away and when spouse 2 passes away. It's very important for the widow or the widower to create or review the estate plan to make sure that the assets are going to go where Barney wants them to go with as little time, cost, and aggravation as possible. Mistake number 10, downplaying probate. I run into this quite a bit. It's funny. I get three, but mostly the first 2. I get 3 general reactions from clients when I mention the word probate, because I do not do a single initial consultation when the word probate doesn't come up. The most common reaction I get when I mention the word probate is a sense of recoil from my clients. They kind of viscerally know that probate is a bad word, something to be avoided, and they're correct in that regard. The second most common reaction I get is one of confusion. They don't know what probate is. It's the third reaction that I get less frequently, but nonetheless frequently enough that it merits its own slide, one of disbelief or confusion. And when I get that reaction from my clients, I will ask further. I'll say, what experience do you have with probate? And almost always the story goes something along the lines of, well, I probated my mother, my father, my brother's estate, and it really wasn't that bad. My next question is going to be, well, roughly when did that occur? And almost inevitably, the answer is going to be more than 20 years ago. Well, Wisconsin has changed its probate laws. It used to be a lot easier and cheaper and quicker to probate the estate. Unfortunately, that's changed over time, such that my goal as an estate planning attorney is to encourage my clients to create estate plans that are guaranteed to avoid probate. That's what I'm looking to do. And again, if we look at the slide, expense is it's time consuming and it's expensive. Time consuming, about an average of 12 to 18 months to probate the average estate. It's expensive, $5,000 to $10,000, and it all becomes public record. And I want to clarify the public record portion, because a lot of times when I mention public record, prospective clients will say to them, well, that's not that big of a deal. I don't really care if the public knows who gets what once I pass away. And I agree with that part. If I didn't do what I did for a living, I'll tell you my estate plan right now, broadcast it all over YouTube. Everything to my wife, if she survives me. If she does not, split evenly between my two boys once they reach the age of 25. I don't care if that's public record. I'm making it public record now. What I don't want public record, and what most of my clients also don't want public record, but what does become public record once we have to have a will filed with the court and we go through probate, is the amount and the character of the assets that also pass through probate. And that's what we're looking to avoid. So again, I always encourage my clients to create plans that are guaranteed to avoid probate. Again, as I mentioned on the slide here, I can't speak for what other attorneys charge for their services, but I can tell you as far as my fees, it's significantly less than even half of the low estimate of the cost of probate above. That not only creates a trust that's guaranteed to avoid probate, but also those powers of attorney that I mentioned before. So again, for an event that we are 100% certain is going to happen, our passing, we have the ability to guarantee that we avoid an expensive portion of that. Mistake 11, engaging in self-help. This is a tougher one because I understand the desire of clients to save a buck or two. I try to save a buck or two where I can. I just, with all due respect and all due humility, I question whether something as important as estate planning is the proper venue to say. Now, I realize I may be biased, but my bias doesn't mean that I'm wrong, right? It means I acknowledge the bias and let you decide whether you think I'm right or wrong. But what I see here is pretty common. I always tell this story. I had a client who was in her mid-90s, and she had 6 children. Well, those 6 children were in their 70s at the time that I met with my client. And unfortunately, 3 of the 6 had already passed away. And when I met with the client had her estate plan that was drafted long before I was ever born. And what she did was she crossed off the names of the deceased children, marked it with a cross, and put their date of death. And what I had explained to this poor old woman was that that was not enforceable, that nobody would know that she did it. We couldn't authenticate it. When it was done, how it was done, putting initials next to it doesn't really matter. Again, if there are changes that need to be made, have an estate planning attorney make those changes. Again, I can't tell you what every attorney will do. I can only tell you my practice. I don't charge for those types of revisions. So it's important we get it right, and it's important we do it in a way that is legally binding. Mistake number 12, hasty decisions. This is a tougher one. And again, for those of you who know me, even for those of you who don't, one of the things I try to do in my practice is I try to leave politics out of it. I have my politics, you have your politics, I stick with facts. When it comes to this, what I can tell you is quasi-political, but I don't take a side on it. What I explain is this. 2016 presidential election, okay, it was a controversial one, to say the least. Between the date of the results, which I think were made official certainly in early to mid-November, until the day President Trump was inaugurated, so about a 2-month period, I had 7 clients call me, 7, who said they wanted to amend their estate planning documents and cut out relatives based upon family disagreements and family fights that occurred between Thanksgiving and Christmas. Think about that. 7 people made that decision. Again, as an estate planning attorney, my job is not to judge. I'm not going to judge whether my client should or shouldn't do that, but what I do urge you to do is think about it. It's the proverbial count to 10, proverbial sleep on it before you make those types of decisions. Because again, we can make those changes. That's not a problem. I do so at no charge for my clients. But if we make the changes and then time goes on and you regret your decision and you never get back to me to make the changes, guess what? the changed version that was made hastily is what's going to govern. So again, while you're free to take into account your own circumstances, while you are certainly free to be able to make the decisions that you want to make as it relates to who and what and how your beneficiaries receive the money, my strong advice is please do not do it hastily. Please consider the pros and cons before calling to make that permanent decision. Mistake 13, relying on cookie cutter forms. Again, I get it. I understand why people might want to save a buck. You can type in Wisconsin Power of Attorney, Wisconsin Will, Wisconsin Trust into Google, and you're going to get something. The question is that document enforceable? Well, unfortunately, this isn't a helpful answer, but the answer is maybe. It depends on the document that you get. Some documents are better than others, but none of them replace meeting with an estate planning attorney of your choosing. And that's why I encourage people to do that, even if it's not with me. Most estate planning attorneys in this area do offer a free or low-cost initial consultation. Learn more about and take advantage of their expertise. At least do that before using the form that's online. That way you can make an informed decision. One thing that I found in my practice is that the overwhelming majority are pleasantly surprised at how inexpensive it is to create an estate plan. I don't know where that comes from. I don't know if it comes from attorney stereotypes about what they charge, whatever the case is, but I very seldom in my practice come across a client who says, that is too expensive, I don't see the value in it. So again, if there is a free, which is what my office offers, a free initial consultation or even a low-cost initial consultation with an attorney of your choosing, find out what they have to say. Have them walk through the pros and cons of that estate plan as opposed to creating one on your own. Mistake 14, listening to the caddy. And I apologize to the people listening on YouTube here. I'll explain the reference to listening to the caddy. I'm a Seinfeld fan. And it's funny, my wife is about 2 years younger than I am, 1 year and 8 months, and she does not like Seinfeld. I believe that I'm at the young end of people who are Seinfeld fans. I feel like people who are much younger than me just didn't get into it at the right time. So I can definitely relate to the older group when it comes to Seinfeld. I think it's one of the funniest TV shows I've ever seen. And when I was preparing this slide presentation, I thought about the scene where Kramer is in court with his attorney, Jackie Stiles. And Jackie Stiles is a competent attorney. He's been doing this for a very long time. And Kramer takes into account what the attorney says. But Kramer, the avid golfer that he is, also brings his caddy to court. He talks to the caddy, and the caddy gives advice that's very different from what the attorney gave, the complete opposite. Kramer, on the other hand, says to his attorney, you know what, I'm going to listen to my caddy, do what the caddy says. And of course, it turns out horribly. The attorney was right, as we usually are. No, I'm just kidding about that one. But the caddy was wrong, the attorney was right, but the attorney followed what the client says as he's required to do ethically, and it turns out that the caddy was wrong and it caused a disaster. So I wanted to kind of bring that scene to light. If you want to Google that scene, feel free to do so. It's one of my favorite scenes from a very funny show. The point is this. I very frequently run into clients or prospective clients who have been receiving advice from their friends, family, church members, and neighbors regarding their own experiences with either estate planning, probate, powers of attorney. 99% of the time this advice is well-intentioned. Nobody's intentionally trying to sabotage the estate plan of another person. That said, they're not lawyers. Not only are they not lawyers, they're not estate planning attorneys. The advice they give may not be correct based upon law changes, based upon circumstance changes, based upon whether somebody was alive or deceased. So again, the remedy is meet with an estate planning attorney to learn the current state of the law and how your circumstances may be different from the well-wishing non-attorney acquaintance. Again, most estate planning attorneys I know offer free or low-cost initial consultations. There's really no downside in getting additional information. Don't listen to the caddy despite how well-intentioned that caddy might be. Mistake 15, not knowing what irrevocable means. I have a lot of clients who are interested in irrevocable trust. I get it. Irrevocable trusts, among other things, are the only types of trusts that allow assets to be protected from nursing home estate recovery. And again, in a vacuum, people think, great, I worked hard, my spouse and I worked hard all our lives, we don't want to have our assets lost to the nursing home. Again, totally understand that, but at the same time, we have to understand what the word irrevocable means. Again, I think most people understand what it means in terms of common English definition, but from a legal standpoint, it means we can't change the document. And again, a lot of times people want the ability to change the document. They want to change beneficiaries because they have that fight over Thanksgiving. They want to be able to update documents because their grandchild, who was 10 at the time they created the document, is now 28 and is a medical doctor. We lose the ability to change documents that are irrevocable. Again, when it comes to revocable, we can change it. Life happens, we can adapt the estate planning document accordingly. But when we create an irrevocable trust, we can't change it. So I always emphasize that with my clients. The ones who are interested in irrevocable trust-based planning, we have to make sure that we understand all of the nuances because we can't go back and change our minds later. So again, it's very important to know what the word irrevocable means in an estate planning context. Mistake number 16, not involving your adult children. Let me explain this one a little bit. There is an attorney-client privilege, and I and most other attorneys that I know take that very seriously. The idea is that I, as an attorney, do not have the right to share information that my clients provided me, confidentiality, with anybody except with their permission. But I'm going to focus on that last part, except with their permission. I encourage my clients, to the extent that they're willing to do it, to have their adult children in the discussion as it relates to the estate plans, just to save problems down the road. I'm going to tell a quick story about that to kind of demonstrate what I mean by involving your adult children and the importance of it. I met with a gentleman a couple of years ago. His wife had passed away a long time ago, 10, 15 years ago, and he was in the process of creating his estate plan. As we were walking through the initial consultation, I asked him how he wanted to divide his assets, as I always do. He said, I want 40% of it to go to my son and 60% of it to go to my daughter. And again, I don't judge, I don't ask any questions. I just took down the information that he said and I asked for their names. Before he provided an answer to that question, he said to me, you're probably wondering why I'm treating my children differently. I said, no, sir, I'm not even wondering that. You tell me how you want your trust, I draft it that way. He said, well, I'm going to explain it to you. He said, my son, I paid for his college, 4 years private school of college at a significant expense. My daughter, on the other hand, received an athletic scholarship. He said, I've provided more during my life to my son as opposed to my daughter, so I want to provide more at death to my daughter than my son. I said, okay, that makes perfect sense. One thing I did tell him was this. I said, as we sit here, does your son know that that's your rationale? He said, no, I don't think he does. I said, well, you may want to explain that to him. Because again, if we fast forward to the time this gentleman passes away, and if that was never explained, the son may think, why did dad only give me 40%? Did he not love me as much? Did he like my sister better? It might cause feelings of jealousy or animosity. Whereas in this case, his reason was a perfectly valid one. I'm not saying it's one I agree or disagree with. My opinion doesn't count there, but it's at least a reasonable one. I said, to the extent that that's your belief, you may want to I may encourage you to talk to your children and explain to them that that's your thought process. I don't know whether he did or didn't, but my point is that to the extent that we involve the adult children, it could help solve some of the conflicts down the road. Mistake number 17, not coordinating with other professionals. This ties in nicely with the previous point about sharing information. Again, if I have an estate planning client, when I meet with him or her or them, the information they share during that meeting is confidential. I can't share that with anyone. Now, usually what I ask and again encourage my clients to do is say, do you mind if I share this information with your financial advisor? Do you mind if I share this information with your accountant or your insurance broker? Because doing so enables me to make sure that there's that harmony we were talking about before between how the legal affairs are conducted and how the financial affairs are conducted. So again, most people listening to this YouTube video are clients or affiliated with Client First in some way. I will ask for permission from my clients to be able to speak with Client First to make sure that we can appropriately update beneficiary designations, ownership designations when applicable, to make sure that the financial works in tandem with the legal, works in tandem with the accountant, and works in tandem with the insurance professional. It's a bit of a cliche, but what I would say is we're all on the same team. We're all trying to help you out, but we need to be able to share, I shouldn't say we need, it's helpful to be able to share information among those professionals just to make sure nothing gets lost in translation. Mistake number 18, not planning for final disposition. We're all going to pass away at some point. We all have different preferences and wishes regarding end-of-life events. Some people want to be buried, some people want to be cremated, some people want a service, but every single one of those end-of-life decisions costs money. Some may cost more than others, certainly, but the event and that occurrence is going to occur with 100% certainty. So how do we plan for it? The answer is create a funeral trust with client first. One of the things I always encourage my clients to do is that setting aside money so that no matter what happens, no matter what our financial situation is at the time we pass away, we've set aside a sum of money that is guaranteed to be used for our funeral expenses so that our children and our loved ones don't have to dig into their own pocket to pay for that. So I encourage everyone who's listening who does not already have a funeral trust to talk to Justin, give Justin a call, and talk about creating a funeral trust, again, to prepare for an event that we are 100% certain is going to happen. Mistake number 19, thinking pods are enough. And I don't mean iPods or ear pods or anything like that. I'm talking pods as in payable on death designations. Payable on death designations is something that you can request through various financial institutions, be it a financial advisor, be it a bank, be it an insurance company that pays money on death, payable on death. As part of my estate planning process, I encourage my clients to use payable on death designations for the assets that they can, okay? But that ties into the solution. Many assets my clients have, we don't have the ability to put a POD designation on. Vehicles, jewelry, electronics, firearms, boats. So again, if we have those assets and those assets in total exceed $50,000, the estate goes through probate. So again, the remedy here is certainly work with your estate planning attorney, take his or her advice as it relates to how we list payable on death beneficiaries, but nonetheless create the trust so that we can guarantee that those assets that we cannot put a beneficiary designation on, that we cannot put a POD on, are still going to be able to go to a trust so that we guarantee that we avoid probate at the time, the cost and aggravation that we discussed before, so that we can avoid all of those. Final mistake here is not following up. Again, I realize that you're taking this time to listen to this YouTube video. I do appreciate that. But again, as I mentioned before, this is merely step one, being receptive to the information. Step two is learning more about how it applies to your situation specifically. And then step three is actually putting pen to paper and signing the documents. I have many clients who can't get over this first hurdle. So congratulations, you've gotten over the first hurdle. If you're listening to me right now, you've made the conscious or maybe unconscious decision to continue to listen to me and learn a little bit more about estate planning. But again, that in and of itself does not accomplish anything. Schedule a meeting and have that be individualized, and then put pen to paper and put those legal documents into full force and effect. I have so many clients who put everything off, and it's at various steps. Usually this is the first step, but I do have a lot of clients who will take this first step, they'll even take the second step and meet with me, and then put it off for several years. So again, my strong advice to you is, just based upon my client experiences, you're going to have to do it at some time. Do it now so that you can enjoy that peace of mind for the longest possible period of time. So thank you very much for listening here. It was my pleasure to provide you with this YouTube video. If you have any questions for me, please feel free to contact Client First or contact me directly at 262-347-3444. Again, 262-347-3444. Again, the objectives of estate planning: transferring assets to intended beneficiaries, paying as little tax as possible, planning for incapacity, and the orderly succession of your estate. If you're interested and want to learn more about my practice, I do have a once-a-month radio show on WISN. In fact, it is next going to be on the air, depending on when you listen to this, of course, the next being relative, September 26th from 3 to 4, which is a Saturday. I do also have a appearance on October 22nd. It is October 24th, excuse me. from 3 to 4 as well. So again, September 26th from 3 to 4, and then October 24th also from 3 to 4. And that's on News Talk 1130 WISN. I thank you for your time here. As you can see, here is the schedule for financial education future lunch and learns. Next month, October 21st, there's the quarter 3 market insights with the adaptive investment management system. So I look forward to seeing you all at that or following along with the video here. And here's some additional information as well. One of the reasons why I pride myself on working with Client First and why I'm blessed to have that opportunity is because they take into account everything. They take into account the taxes, Social Security, Medicare, the investments, as well as the insurance, and along with partnering with me as the estate planning attorney. Just like with me, they offer a free, no-fee initial consultation. And I encourage you to, if you're not already a Client First client, meet with them. Give them the opportunity to work with you and see if there's an overlap between the services that they offer and the services that you need. I thank you very much for your time. Have a wonderful day.